The last case set for argument this morning is Kate Kane versus Inpatient Medical Services, Inc. et al. Case number 29087. We'll note that there is another similar case, Kate Kane versus Inpatient Medical Services, 29148, that's submitted. We're only going to be hearing arguments on the 29087 case. Appellant, or I should say each party, has 15 minutes for their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you keep an eye on the clock there and you're going to rebut time, that'll give you an idea where you're at, or I'll try to remind you. Just let me know how much time you would like to reserve. Please keep your voice up as the arguments are being recorded and they are posted on the court's YouTube channel. And we've read the briefs and are ready to proceed if you are.
Thank you, Your Honor. My name is Brett Mancino. I am on behalf of Kate Kane, the appellant in this case. I'd like to reserve 5 minutes for rebuttal.
Very good, thank you.
As this court's aware after reading the briefs, this is a FMLA retaliation and interference claim on behalf of my client, Kate Kane, who was a very competent and successful vice president at IMS. And when she went on her second pregnancy leave, during that interim period, IMS was purchased by Island Medical out of New York City. Now, my first assignment of error is that the Exhibits 6 and 7 were improperly excluded from consideration by the trial court judge. The defendant's argument was that those are settlement agreements and they're inadmissible under the rules. However, the rules in the case law specifically states that if settlement agreements are used for another purpose other than to show liability, they are in fact admissible. And that's what they were used for in this case. During the discovery period, interrogatories were issued to the defendants as to the reason they terminated Kate Kane on her first day back after FMLA leave. And they said she was part of a 15 to 20 person RIF, reduction in force. They produced documents that, not only did they not produce documents supporting that, they produced documents in discovery showing that that 15 to 20 person RIF applied to the Indiana company, to clerical staff and clinical staff. Kate Kane was management. So their profit reason is used to those documents to show that their profit reason is false and inconsistent. And the jury should be able to see that. Which goes then to the merits of the claim, assignments of error 2 and 3, that Kate Kane was entitled to have her job restored, and that the RIF was not true. And I was showing that it was not true because of the documents that were produced by the defendants, the separation agreements from the employees at the Indiana company. So the jury should be able to make those factual determinations. And going into the merits of the claims, all of the decisions by the trial court judge were factual decisions that a jury should decide whether or not that the defendants had a legitimate reason for terminating Kate Kane. Those questions should not be decided as a matter of law by a trial court judge. That's a jury question. And at the heart, again, of the jury question is Exhibits 6 and 7. Finally, assignment of error 4, we raise an appeal as to the whether or not the trial court properly struck the jury demand itself. And we argue that the waiver of jury trial, although included in the employment agreement, it did not specifically address claims for violations of federal or state employment law. And therefore, Kate Kane, although sophisticated in her position, she did not knowingly, voluntarily, or intelligently waive her right to bring a case based upon federal or state employment law. And therefore, we argue that that was an improper decision by the trial court judge. In addition, the cases cited, like the Princess Kim case cited by the defendants, that was an agreement, a consumer agreement, where it clearly applied in that case. But this is an employment case, and both parties had the opportunity to waive specifically employment-related claims, and that was not done in this case, and therefore the decision to strike the jury waiver was also error. And again, just to put the broad picture in this case, that the decision made by the trial court judge were factual decisions, credibility determinations. Those are decisions left for trial of fact, whether it's a jury or a trial court judge. And it was error for the trial court judge to dismiss the FMLA claims. And I point out that I think the defense takes note that while she took a leave before, and they had no problem with it, and she's taking her second leave. Well, again, that first leave was taken with IMS. Technically, the second leave was taken with this New York company, this out-of-state New York company, and the jury could infer that they were not happy with the fact that she took FMLA leave, and there was absolutely no reason that they should wait to fire Kane on their first day back from her leave. And the courts held that temporal proximity alone is sufficient for a jury to infer improper motive, and therefore we're asking this court to reverse the trial court's judgment, excluding Exhibits 6 and 7, and dismissing the FMLA claims, as well as striking the jury demand.
Did you indicate earlier in your argument that the reduction in force did not apply to management, just applied to clerical persons?
Yes.
That's the case here?
Yeah, it was the 15 to 20 person RIF that it applied to was this those are sort of a related or unrelated Indiana company, and they're all nursing staff, they were hourly wage employees, and that was Exhibits 6 and 7. And specifically, I don't have the interrogatory, I think I cited it, but the interrogatory number, I specifically asked, state the reason for terminating Kane. She was subject to a 15 to 20 person RIF. That 15 to 20 person RIF were these employees in Indiana, not management employees in Kane's position. If there's no further questions.
Judge Schaefer? Okay, thank you very much. You'll have full 5 minutes for your rebuttal. And counsel, you'll have, of course, 15 minutes for your argument.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court. My name is Nathan Pangrace, and I'm the attorney for INS and Island Medical. I'm going to start right away with Kane's first assignment of error. We'd argue that the trial court correctly refused to consider the settlement agreements when it decided upon INS and Island's summary judgment motion. Evidence Rule 408 says that offers of compromise that include settlement agreements are not admissible to prove liability. The exhibits in question here are settlement agreements between IMS and Kane, and a settlement agreement between IMS's subsidiary and one of that subsidiary's employees. Kane is trying to use these settlement agreements to contradict IMS's argument that she was subject to a RIF. She's trying to show that the reason for her layoff is false and the discrimination is the real reason. So she's using these arguments to prove liability for discrimination, and that's what's expressly prohibited under Rule 408.
But 408 really is getting to the fact that you don't want a jury thinking because they offer to settle, that therefore that the defendant is guilty of wrongdoing, is liable.
Sure. But I think a jury could infer that, and if these settlement agreements were allowed as evidence at trial, then I think a jury could reasonably infer that IMS was trying to settle these claims with these employees because they thought there was some liability.
But
So,
couldn't there be some type of jury instruction or caution in regard to that, or couldn't there be some type of, way to not include all parts of the agreement to try to protect that?
I suppose so. I suppose that's possible. But we think the language of Rule 408 is pretty straightforward, that offers of compromise aren't admissible, and these were clearly settlements agreements that were offered to these employees in order to resolve their claims and compromise those claims. So we'd argue that they fall within the purview of Rule 408.
But the only issue I'm wondering with that, it seems like then any exception to Rule 408 would seem to just be swallowed up in your definition of what is going to liability. Because if something wasn't going to liability, it would be relevant anyway in the trial.
Right, and there are some exceptions to the rule, which is negating a claim of delay, proving bias or prejudice, obstructing a criminal investigation. None of those exceptions are relevant here.
But those were just examples.
Sure.
Bias and prejudice, though, why wouldn't that be going to liability?
Well, I don't think it is. I think that's one of the exceptions under Rule 408.
I'm saying if it's in this situation,
that's
agree?
not, I would agree, yeah, but I don't think that's what Kate Kane is using his agreements to show.
I understand that, but what I'm saying is, with your reasoning of, anything going to liability, you could never use any, the compromise or settlement at any time. In other words, it swallows up the exceptions, because bias and prejudice could be going to the issue of liability. And that's listed right in the rule.
Yeah, that's true, but I mean, I think the rule is supposed to be interpreted broadly. It's supposed to encourage out-of-court settlements, it's supposed to reduce the caseload of the court docket, so, I mean, we'd argue that that rule is supposed to have a broad effect. More importantly, though, I think that even if the court had considered these agreements, it would have been harmless error, because they're not evidence of pretext like Kane is arguing they are. Kane's settlement agreement specifically states that she was being laid off because she was subject to a reduction in force. The other agreement is a settlement agreement between the subsidiary, AHA, and the employee, Linda Avila. That agreement had a list of employees that were subject to the RIF, but that list was included in compliance with the Older Worker Benefits Protection Act. That specifically requires that kind of information for an employee who is over 40, and that's why that information was attached to the settlement agreement. Now,
So
Kane,
Kane was management, correct?
correct, yeah.
And did the RIF apply to management level employees?
It absolutely did, yeah. And Kane's claim that the RIF only applied to AHA and clinical employees is absolutely not true. And that's nowhere reflected in the record. When Island purchased IMS, it was a global RIF. The RIF included both the subsidiary AHA and IMS. There were about 15 employees of AHA that were included in the RIF, and there were 2 employees of IMS that were included in the RIF. Those employees were Kate Kane and the CEO, Mark Foster. That's consistent throughout the record. It's very clear. Shouldn't be any dispute on that.
And neither of their names were on the agreement.
Correct, because when the settlement agreement was offered to Kate Kane, she was actually under 40 years old. So IMS was not required to include that information on the settlement agreement because the Older Worker Benefits Protection Act didn't apply.
And CEO as well.
Correct, yeah. And she was also left off the list that was attached to the other agreement, Linda Avila's, because Kate Kane was not an IMS employee, or she was not an AHA employee, she was an IMS employee. So
Right.
it made sense for her to be excluded from that agreement.
Okay, but the CEO was under 40 as well?
That I don't know. I think he was over 40, actually.
You said he wasn't included on the list?
Well, he wouldn't have been included on the list with the AHA settlement
Right,
agreement because
but
he
on
would.
the other one, you said the only people in there were people that were over 40 because it was required to put them down because of their age.
Correct, yeah. I don't know if Mark Foster was included on a list attached to his settlement agreement or not. I don't think we ever saw that settlement agreement in discovery. If he was over 40, there would have been a similar list included, required under the Older Worker Benefits Protection Act, but that was something that was never requested or exchanged. Moving on to the second assignment of error, the trial court correctly granted summary judgment on the interference claim. Kate Kane cannot show that IMS denied her a benefit under the FMLA that she was entitled to. Now, the FMLA does say that employees should be reinstated at the end of their leave, but it's specific that employees don't have unlimited reinstatement rights. An employer can lawfully dismiss an employee if the employee would have been dismissed regardless of the leave. So Kane is not entitled to reinstatement under the FMLA because IMS and Island eliminated her job as a result of reduction in force. Her position was redundant. There were other employees at IMS who were doing the same duties that she was doing, most specifically Dr. Greg Ferner. Many of his duties overlapped with Kate Kane's, so Island determined that Kate Kane's position was redundant.
Now, let me ask you a question. Is it your position that the employer, IMS, would have notified Ms. Kane while she was on FMLA leave before she returned to work that her position was being eliminated?
I'm sorry, I'm not sure I understand the question.
Well, according to the record, as I understand it, she was brought back to work,
Correct.
reinstated. I mean,
That
there seems to be
was
some
a matter of
argument about
semantics,
that. Yeah.
right, yeah.
But she was definitely brought back to work. I assume she was paid that day.
She was notified that she was being laid off the first day that she was back.
Okay, I know, I'll get to that. I'm sorry, I'm trying to get to a point. So she was brought back, I assume she was paid, so the argument could be made she was reinstated. And then she was told that her position was being eliminated.
Correct.
So my question is, could IMS have notified her and eliminated her position while she was on FMLA leave?
Sure, absolutely. Yeah, the FMLA doesn't shield an employee from an otherwise lawful layoff.
So what was the point of bringing her back and doing it that way?
To be honest, Your Honor, I don't know. I think possibly they wanted to, I don't know, refrain from giving her bad information while she was out on leave raising her second child. I don't think they wanted to disturb the leave, so they waited until she came back. But, I mean, really the timing wouldn't have made a difference because simply the fact that she was on leave didn't protect her from a lawful layoff, and that's what happened here because her position was eliminated.
Of course, they're saying it did harm her in the respect that she thought she was coming back to a position and could have been looking for work during that time period.
That's true, but she was
I'm
also...
not saying that's necessarily illegal, I'm just saying that that's one of the arguments.
Sure, that's one of the arguments. I mean, the other argument is that she was out on medical leave because she was caring for a newborn child, too. So how much of a jump start was she got on that medical, that job search while she was caring for a newborn? You know, we don't know.
It's amazing what you can do with a computer now.
That's true. The claim also fails because there's no evidence that the reasons for the layoff and the inclusion in the reduction in force are protectual. Like I mentioned earlier, there's no evidence that the layoff only applied to the subsidiary or clinical employees. It included both IMS and HA. It was a global reduction in force. There were never any shifting reasons for terminating her in this RIF. The only reason that the company ever gave for letting her go was this elimination of her position due to a reduction in force. Like I said before, IMS and Island determined that her job was redundant. Most specifically, the duties overlap with Dr. Ferner. Dr. Ferner was responsible for managing client relationships, overseeing operations, doing training, doing recruiting. Kane specifically admitted in her deposition that she did all of those exact same things. She also made the claim that male employees at IMS had the opportunity to interview for their jobs with Island in order to talk about staying on after the reduction in force. Again, that's not entirely true. She identified 3 employees. Dr. Ferner was one, Justin Meiser, the VP of Finance, was the other, and Davidson Cannon was the third. I think first and most importantly, Kane was not present for any of these conversations. She doesn't know anything about what was discussed firsthand. Anything that she testified to as the contents of these conversations was all hearsay.
But they were opposed, right?
Correct, yeah. And Justin Meiser, as the VP of Finance, he was assisting in the merger. He testified that his discussions related to business strategy and financial issues. He specifically denied discussing his job duties with Island. He specifically denied discussing the possibility of staying on with Island after the merger. Very similar with Dr. Greg Ferner. He said that his conversations with Island were just general discussions. One of those conversations, he met the new, I believe it was the CEO or CFO of Island, new parent company. He again specifically denied discussing his job duties with Island and the possibility of staying on with Island after the merger. Now there was one employee, Davidson Cannon, who did have a discussion with Island about his job. He was the compliance officer for IMS. But the fact that this one person had the discussion is not evidence of pretext because he and Kate Kane were not similarly situated. In order to demonstrate pretext under Ohio Revised Code 4112, Kate Kane has to show that comparable employees were treated differently. And to show that, she has to prove that she and the comparable employee were similarly situated in all relevant respects. That wasn't the case here. As a compliance officer, Davidson Cannon was responsible for human resources, complying with state and federal laws. Kate Kane was the regional VP of operations. She did the same things that Dr. Ferner did, like staffing, recruiting, scheduling, overseeing day-to-day operations. So they had totally different positions, totally different job duties. Following the merger, Kane's role was redundant. Davidson Cannon's role was not redundant following the merger. So that is why Kate Kane was included in the RIF and Davidson Cannon was not. There's a very specific distinction which explains why Island treated them differently with respect to the murder. Moving on to the retaliation claim, this claim fails because there's no causal connection between her leave and her inclusion in the RIF. She was fired on her first day back, but contrary to what Kate Kane has argued, the vast majority of cases say that timing alone is not sufficient to demonstrate a causal connection. That's very clear in the Sixth Circuit jurisprudence, which Ohio relies on when evaluating FMLA claims. Again, the reasons for her layoff were non-retaliatory. There's no evidence that the leave played any role in Island IMS's decision to include her in the reduction force, and Kate Kane specifically admitted in her deposition that she couldn't point to any evidence that her leave was used as a factor. Turning to the last assignment of error, we also argue that the court correctly struck the jury demand. She wasn't entitled to a jury because she signed this jury waiver. The employment agreement specifically contains a waiver of a right to a jury trial in any matter directly or indirectly related to her employment and the employment agreement. Ohio courts say these waivers are enforceable. It's plain language, it's clear and conspicuous, it's in its own number of paragraphs, it's in capital letters. Also importantly, it's mutual. Both Kate Kane and IMS waived their right to a jury in this kind of litigation. The waiver was knowing, voluntary, and intelligent. Kane's a college-educated employee. She has extensive experience in negotiating contracts. Before she came to IMS, she was a manager of a staffing recruiting company. One of her duties there included negotiating contracts. She also negotiated contracts when she was at IMS. So she had a lot of experience reviewing and negotiating contracts. When she signed this agreement with IMS, there was a level playing field. She was able to negotiate a higher salary with IMS. She negotiated her entire severance package. And 1 year after she signed the agreement, she negotiated a higher salary to $135,000. There's no evidence that she was coerced to sign it. There's no evidence of any fraud or duress or anything like that. There's no requirement under Ohio law that IMS explain the contents of the agreement to her. Rather, Ohio law just says the party is bound by the terms that are in the document.
And with that, you are out of time.
Okay. Thank you.
Thank you very much.
The court to affirm the judgment of the trial court. Thank you.
Thank you for your argument. We'll hear rebuttal, 5 minutes.
Thank you, Your Honor. As I heard Appleby's argument with regard to assignment of error number 1, I've heard a litany of reasons why Exhibits 6 and 7 were used other than to show liability, to show that the reasons given for the termination was false and contradictory. Significantly, again, on page 4 of my brief, I cited Exhibit 1, interrogatory number 13. And I asked, state the reason for terminating Kate Kane. She was subject to a RIF of 15 to 20 employees. Significantly, even if you want to exclude my proponent, my proponent of these exhibits, there's no evidence by the defendants, by the appellees, to show that she was part of a 15 to 20 person employee. So again, there's negative information from the defendants. With regard to Greg Ferner, I think, and Davidson Cannon, who testified he was able to talk about his job, granted he is the Human Resource Director. The other individuals were all males, and I think the jury, the trier of fact, should be able to see and determine the credibility as to what all these discussions were, because there were several. Greg Ferner testified he had several discussions, several meetings. He went to Hudson to meet with these guys, and he classified it as, they're just business meetings, but I think we delve into it more. He could infer, jury, the fact finder could infer that there were other topics being discussed. And Ferner, and I can't find it in my brief, I'm sure, when I read it yesterday, I'm sure I put it in there. Greg Ferner testified he wasn't doing Kate Kane's job. So I think there's contradictions all over the place. There's credibility determinations to be made. There's factual issues in dispute that a fact finder must decide. And I'd ask this court to reverse the trial court's dismissal of this case and rule that specifically that Exhibits 6 and 7 are admissible and that Kate Kane is entitled to a trial by jury.
Did she actually testify in her deposition that she did not feel the FMLA was a fact? The FMLA was a factor in her decision in their decision to reduce the tax portion.
Is your question
she did not feel,
No, I believe, I don't know the specific testimony, but I believe, I mean, that's where we brought the lawsuit, that she feels that she was terminated in violation of the FMLA.
I'm trying to remember what her testimony during her deposition was, though.
Yeah, and again, some of this, an employee doesn't ever, I mean, but that's part of the issue going on in this case. She's terminated. She was shut out from discussions. She doesn't know exactly what the behind-the-scenes discussions were, but she knows that there's a law that protects her, and that's what this is based upon. And it's allowed, and the fact finder is supposed to be the one to make these factual determinations.
All right, I thought there was some evidence that she testified that there was no evidence that her FMLA leave was a factor in the decision to reduce the employee.
I don't know if there's any specific testimony, and and if there is, I would attribute that to her being a lay person, not understanding the law and the specifics of it. It's a very nuanced question. I think if that was asked, I don't recall that testimony. But,
All right, thank you.
thank you.
Victor, anything? Paper? Thank you both for your arguments this morning. We'll take the matter under advisement, and the courts will issue, send you copies of the court's decision once we issue our opinion. By the way, they are also posted on Supreme Court of Ohio's website. Court will be adjourned then.